Well, good afternoon. Thanks very much for coming to Overcoming Adversity. Fancy way of saying that we're going to be helping you identify and deal with problem franchisees. I always say that one problem franchisee costs about as much in terms of time, energy, and money as 10 good ones. It is extremely important to identify them, to avoid them in the first place, to identify them and to deal with them in a cost-efficient way. We have a terrific panel here today. I'm going to introduce myself. I'm Peter Viitre. I'm a franchise attorney based in Toronto, Canada. I've been doing franchise law for about 25 years, and I am delighted to be your moderator today. Chris, why don't we start with you?
Hi, I'm Chris Walls. I'm the CEO of Gominis Portable Storage, and I'm a recovering litigation attorney as well. So.
Hi, I'm Frank Reino. I'm a partner at Zucker. I've been working with Lane for 17 years now, and I hope to someday be a recovering litigation attorney.
Well, I'm not going to say I'm a recovering franchisor, but Josh Skolnick, co-founder of Horsepower Brands, been in franchising now 12 years and have awarded well over 1,500 franchise units amongst all my companies. So when it comes to franchisee disputes, I think I'll be able to provide a lot of value because of the number of owners that we've worked with.
Well, that's terrific. Listen, we've got a small enough crowd. We certainly welcome questions as we go. We want it to be an interactive discussion, and I'm sure you have some questions for these folks, and hopefully we'll be able to cover them off. So don't hesitate to put up your hand, and we will call on you. So Josh, why don't we start with you then? So how, as a franchisor, do you identify a problem franchisee? What kind of tools do you use? What kind of systems do you have?
So we over the last couple of days, you heard a lot about data. So that's where we really start looking at building out good dashboards and being able to track the metrics. We always talk about in supporting our franchisees, we drive the support through the data that our franchise business coaches can see. And so we can identify bad apples sometimes just merely based on performance. But performance isn't the only thing that drives bad apples within a franchise system in my experience. Sometimes you can have individuals that are doing well, but there's also a level of buyer's remorse or something that they thought through the development process was promised to them that they're not getting. So being able to leverage things like your franchise advisory council, to be able to use them as an avenue and a channel for your franchisees to speak openly. We use an insider at Horsepower Brands for each one of our organizations where the franchisees can communicate. We try to do our best to mediate that stuff, but we also want to give them some level of privacy at the same time. But what you will find in life in general, it's very hard for some people to keep things confidential and keep secrets. So regardless of size, there's always going to be a few rats in that group that are going to run back to the FAC or the franchisor and share it. But what you have to do is you have to act fast. We find really chasing any or going head on with any sort of conflict is always going to be your best resolution. And sometimes it may not be easily resolved, and it might have to be worked out through somebody exiting the system, either through a resale and or leveraging things like defaults to get people within line.
No, that's great. Frank,
I'd like to follow up on that a little bit. So like Josh was saying with data, I think part of the data that you need is you need to enforce your agreement. You need to make sure your franchisees are doing what they're supposed to do from the moment you sell it to them. I see the problem that I see, I think, a lot is the franchisees in the build-out stage, right? The franchisor sells the franchise. And a lot of emerging brands are so focused on the sales end, they forget about the development end, the build-out, the construction, the getting the franchise location open. And the franchisee will go out on their own and start doing that, and their expenses may begin to run up. They may get a bad bid from a contractor, not realize that that's a bad bid, and later on they're going to blame you because their build-out costs more than your item 7, right? So I think it's extremely important not just to focus on the sales end, but to also focus on getting this place open, getting this franchisee open, following along, checking their progress, looking at what the bids they're getting. If you see that their expenses are above what your item 7 expenses are, try to find out why. Try to address that problem early on, because I think a lot of your bad franchisees are usually franchisees who are unhappy with you, right? Because they ended up spending a lot more money to get open than they expected. And they're going to blame you for that. Even if it's their fault, they're going to blame you for that.
Chris, how often do you go out and see your franchisees and monitor what they're up to?
I try and look and get out there at least once a year. One of the things, we're a container company, portable storage containers. They come in, they have to be put together. When they order new containers, I'll take that as an invite and say, hey, I'll come down and I'll help you put these containers together and work with them. And then take them to dinner and you learn what's going on, you learn what issues there are. And so at least once a year, and I just brought in a VP of Ops who's going to visit with them once a year, so they'll be getting 2 visits a year going forward. But also just to back up a little bit on, identifying problem franchisees, which I have a couple of. My question is why? Because it really starts with performance for us. We look at performance and like, wow, they're off. Everyone else is growing by 10, 15, 20%, and these guys are shrinking. Why? And then you look at the data, as Josh says, and you go through there, and then it's maybe another personal visit and trying to really dig down. Are they following the rules? Or is there the back channel that Josh was mentioning that, like, no, somebody else figured out another way to do it and it's better and that sort of thing, and then it's really hurting their business because they don't understand the impact that has on the system by what they're doing. So for me, it's the first question is performance, why? And then go from there.
And how often do you bring in attorneys, and how quickly do you bring in attorneys? Being one yourself, you may not need them quite as often,
Yeah.
but
I don't wear the legal hat at GoMinis, but it helps, it does. But I consult attorneys a lot just from perspective of, is this correct? This is my interpretation of the section and that sort of thing. But what I've discovered is franchisees don't like the whole legal hammer. So if you're going to go down that path, it makes it a more difficult decision, in my opinion. So what I try and do is find out really understand what my rights are, what their rights are from looking at the agreement and looking at the facts of the situation, but then try and soft pedal it in the beginning. And so, I've consulted with the attorney in the background, they don't know that, or I've come to my own legal conclusions, and then I'll go out and say, if you take a look at the agreement, you probably can't do that. And, and there's a reason, and give them kind of the factual reasons why that's in there, and get them that way. And then we start down a path. But, so it starts out really informal with an informed decision on our end, but loaded so we know what to say and how to say it. And if we followed up in an email or something like that, it's going to be used. You got to start thinking when someone is not performing or they're a problem, you got to think that this could ultimately end up in litigation or arbitration, depending on your franchise agreement. You got to start thinking about that. When I put things in writing, they're going to use that, or you're going to need to use that. So.
and
I'll add to that a little
yeah,
bit.
that'd be great.
So I would add, because I'm sure we have a lot of emerging franchisors in the room, you're going to have to leverage legal counsel early on if you have issues, because you don't have the experience of how to navigate the problem. So one of the key pieces of advice I always give to my leadership team, and including myself, is make sure you understand the agreement that your franchisees are signing, because many franchisors get into franchising because they work with a marketing company that helps them turn their business, their corporate store, into a franchise system, and you know little to nothing about why there's certain language going in that agreement. So understanding if there is a dispute with a franchisee, what's the proper procedure that they have to follow? Or is there anything in there, like say a mediation clause, that you might be giving up your rights because when you receive a notification from them of a dispute, you may not preserve that right for mediation within whatever window you have in your FDD and things of that nature and your franchise agreement. So make sure you do understand those documents, and always try to resolve a dispute if you can without the lawyers involved. So if you are just using the attorney to consult, it's going to be much easier to resolve things when you're working directly with that franchisee. Don't be afraid to make financial concessions, and think about ahead of time. I'm always trying to think 1 or 2 steps ahead. Like as we're launching new brands, because we primarily acquire businesses with 3 or less operating locations. So we're doing a lot of that early building, and we're doing it with an average of 100 to 200 new units sold on a brand in the first 12 months that we own it. And so we're thinking, as we're launching these things, what are some areas that we could be strategic, where we could give a little bit if an issue comes up, or we're also monitoring it to be proactive, to maybe look at potentially if we see something that's becoming a system-wide issue or an opportunity to where some of the early, call them guinea pigs, those early adopters and first movers, are maybe having some financial impact in certain areas because a marketing piece didn't work appropriately, or a piece of equipment wasn't the right fit, or we found a better way to do things for less money. Where are some financial concessions we could make, either short-term or long-term, to make them feel good about being that early mover and not feel that they have to go to an attorney to try to fight for something for them?
And I would just add to that, any financial considerations that you give the franchisee, make sure you get a release from them. That's extremely important. Do not give them anything without getting a release in return, because that eliminates their ability to come back later and complain about anything that happened prior to that date. So that gets rid of all their FDD claims they may have, or they may come up with. They can't raise those later because now they've released you from them. So, and it's really important, I think, and beneficial to do it early in the relationship, right? Because they're new franchisees, they may still be excited about the concept and the idea, and so they may not be as opposed to the idea of giving you the release. You know, once it becomes a fight, you're less likely to get them to agree to the release. So it's always, it's always important, I think, to identify these issues as early as possible in the relationship to try to give them that financial consideration in return for a release.
So when you give these financial considerations, how do you deal with the fact that franchisees tend to talk to one another, and next thing you know, everybody's asking for the same thing?
I've always been a firm believer what's good for one is good for all. So if you are working out some sort of a concession that you don't believe is going to be something that's kept in confidence, then you should really consider offering it across the board as a temporary concession if you are doing something along those lines.
I agree with that everyone knows everything of what you're doing. And the bottom line is, when we cut a deal with someone, that deal, someone has to be on the same factual situation. You'll give that person, the next person, that same deal. You can't just give one. It creates all kinds of trouble for you.
And then you just got releases from everybody.
Yeah, and you will have people ask you, like, well, why do I need the release, or can't we just do this on a handshake? And they're always going to tell you, well, I won't be that person. I'm not litigious. I would never bring anything against you. But when things don't go right, they definitely come back, and it's amazing the number of times those releases will save you.
Frank, can you tell us a little bit about the steps, the escalation of enforcement when you do find a franchisee that's got a problem?
Sure. Well, I think it depends on the type of default you're dealing with, right? I mean, if it's a serious default, a monetary default, you've got to send a default notice. You don't really have. I don't think you have too many options there. If they're misusing your brand in some way, they're maybe, if it's a restaurant and they're serving food in a dangerous way, I think you have no choice there but to send a default notice. And one thing I want to say before I forget is, make sure you consult with your lawyer before you send that default notice, because many states have different statutes on relationships, and some require you to provide a certain amount of cure period before you can terminate. So if you send a default notice and you only give them 10 days because your franchise agreement says you have 10 days to cure, but you're in Minnesota and Minnesota requires you to give them 30, you won't be able to terminate. You'll have to send another default notice. And now the problem's going to get worse because you're not able to get them out of your system yet. So I think that's an important consideration. Now, if it's a lesser type of default, I don't know, say they're using an unapproved vendor, or you do an inspection, or they're not wearing uniforms right, or any of those slightly minor issues, I think you shouldn't raise those to the level of a default, because you're going to just alienate that franchisee over something minor, right? So, I guess it depends on your style and your personality, but I think you should maybe call the franchisee up, give them hey, we understand that this is an issue. I'm reaching out to you to give you a chance to fix it. We're going to send you not a default notice, but maybe a warning notice. Call it whatever you want. Don't call it a default, right? Say, you're out of compliance. We're not defaulting you, but we need you to get in compliance, and you have so much time to do so. And if they, a lot of times I think a franchisee might respect that and appreciate that. Maybe it's just the franchisee needs to be trained again. Maybe they don't remember what the rules are, because there's a lot of rules sometimes, right, about brand concepts and operations manuals. And some franchisees probably never even look at their operations manual, right? So, I think it's important to maybe say and offer them something like that. Hey, maybe you need to be retrained. And if you're going to, we'll do it free of cost. We'll give you another chance here. You can come in, we'll retrain you, we'll give you some more tips, we'll make sure you know what you're doing. And, because we're waiving the fee, you please sign a release, right? As you can tell, I love releases. But yeah, so I mean, I think that's, you can, you elevate it slowly on those types of situations. But it depends on the situation, I think.
And you raise an excellent point that we're really, the flip side of the coin to enforcement is that support. And it may not be a carrot necessarily that you're giving out, right. But there is a teaching element to it, and there is a support element to it that hopefully your field folks will be able to get to the bottom of the performance problem and frankly help them correct it. Yeah. And that may take some time. Do you have any thoughts, Chris, on this?
Yeah, I when I came into GoMini's, there were some compliance issues, and they still remain to this day. And I've been very patient, much more patient than I would be as an attorney, honestly. And it's kind of like when I look, it's like, well, I have 15 franchisees that aren't doing this. So what am I going to do? Default 15 franchisees? No. So what I've tried to do is use the carrot and say, listen, you're not using the approved vendor for marketing, and that actually hurts us by this, this, and this. And although you're also missing out on co-ops, because I'm not going to co-op an unapproved vendor, but I will with this vendor and that sort of thing, and try and get them back into the fold that way. And then slowly, hopefully, you bring over, maybe I can get 7 or 8 or 10 of them, and then now I'm dealing with 5 or 6 that are holding out, and that's if I have to start with the default notices, then it's a lot less. So I've set up several programs with like incentivizing people to do the right thing, and I've had decent success with it. I wouldn't say 100%, but it's a path, and take my time.
Yeah. Josh, do you have anything to add?
I would just add before we get to the question quick, Frank talked about training, making sure that you're documenting all of the things that you're doing with franchisees to support them and train them. So think about, it may come across as cheesy that when someone finishes their initial training, having them, just sign off that they've received the satisfactory training or given them some sort of a certificate that they completed it, because when disputes arise to the level that you can't resolve them internally, you're going to need to have all of the notes of everything you did, and keeping track of all of the communications you're having. Like at Horsepower Brands, we have an internal system that our franchise business coaches, our brand presidents, any department that interacts with a franchisee, they have to put all of those notes into a system, and then everybody within that organization has access to be able to see it at the leadership level, and then our entire executive leadership team can see it as well. Because if you think of myself in my role as a co-founder at Horsepower, we've got over 1,100 units now, and if I get an email from a franchisee because they want to do an end run and just go past everyone that they're supposed to be working with, I want to be able to have all the facts right in front of me and then be able to steer them right back to where they need to go. So I'm not spending time getting on a call for 15 or 30 minutes, hearing them, regurgitate a story that they might have been talking to other people about, and get them right to the right channels to where they need to help, and save that time to be as efficient as possible, but also protect ourselves.
Yes, you had a question, sorry.
Yeah, so you talked about franchisees not complying with certain things, and you work with them, and you might have a number of those different locations doing the same thing. So you have this infraction taking place, you work through it, you put it right. And in the future that happens again, and it happens again. At what point can you actually enforce it? At what point do the franchisees say, well, you made an exception there, you made an exception with them? Where does that leave you?
Well, as I said earlier, from the exception standpoint, when something occurs, word does travel, and just think of none of the conversations you're having with any of the franchisees are going to remain confidential, even though there's a confidentiality provision in the agreement. They just all love to share things. But what we do is we use a little bit more of like a passive aggressive approach, where if somebody's a continual offender of an issue, rather than just want to jump to a termination and push somebody out, we'll spin it to a resale that, like, hey, maybe this isn't the right fit for you, or you're not cut from the right cloth to be a franchisee because you want to create your own model, because that's dangerous when people want to say, well, I have my own model that I run. Like, I remember the first time I heard a franchisee say that years ago, I just about came unglued, because it's like, why did you spend money to join this organization if you're going to run your own model? And oftentimes, you'll have franchisees that think they're the smartest people in the room, and because oftentimes someone buying a franchise is an accomplished individual, whether it be, a high net worth individual that's worked for someone else helping to build companies or manage large teams or maybe owned independent businesses. But oftentimes the franchisees coming into your business know little to nothing about that industry. So they're really relying on you as the expert, and taking that approach to say it may not be the right fit and we should have a conversation around resale is not a bad thing. I will say in my businesses, the word resale doesn't scare us. Oftentimes franchisors are intimidated by people that want to resale because they're afraid that they're losing an operator, someone that they already have a known relationship with, whether it be positive or negative, and they don't know how that new operator is going to come in. In my experience, the new operators breathe new life into it and take it to a different level, because you have two types of investors from my perspective. The one that's comfortable with the sweat equity and getting it at a lower rate by paying an initial franchise fee and then investing off of the required investment you have in your item 7. And then you have that investor that wants to try to buy cash flow and is willing to spend more money to buy that operating business, and is going to now come in and they have more of that investor mindset than that initial franchisee that's going to put more of that sweat equity into it.
From a legal perspective as well, I mean, there are problems that you get into if you let things go for too long, and it's not necessarily that easy to reinstate strict enforcement. You have to give notice, and it's never 100% clear how much notice you have to give. You can do it, but it does take a little bit of time, and the longer you've let things go, the longer the notice period is going to have to be. So from my perspective, it's always best to be on top of it, and frankly, it's not even necessarily about the one franchisee reoffending. It's the fact that they all see it, the other franchisees all see it, and you're letting so-and-so get away with something. They want the same kind of deal, and the next thing you know, you've got anarchy. It's not sustainable.
And that comes down to consistency.
That's right.
Being consistent with making sure that, just because you have a franchisee that you may not like or you might not have the best relationship, if you want to just drop the hammer and go, all right, we're going to make an example of this person. If you haven't done anything from default notices or terminations before, it's going to come across as if you're discriminating a single individual.
Yeah, that was something that was my point in the beginning when I said enforce your agreement, right? Keep track of what they're doing. Enforce those provisions. If you have, for example, quotas, this is one that always comes up in my litigation cases. You have quotas, they don't meet their quotas for the first 5 years of their agreement. Now you're fed up with this person and you want them out, and you want to use that as your reason to get them out, right? Well, they're going to come back, and their lawyer is going to come back and say, well, you let me do it for 5 years. What changed in year 6? And you let this guy do it, and you let this guy do it, and you let that guy do it. It becomes extremely difficult for me to prove I had the right to terminate that franchise agreement when you let it go for so long. So you gotta keep track of these things, these obligations. If they're supposed to send you their tax returns every year, as they're required to do in a lot of franchise agreements, make sure they send it. Have a checklist. Did I get everybody's tax returns? If not, send a letter to the guy who didn't send them. That's maybe one of those warning notices, because it's not the most serious breach, but that's the kind of thing you have to do. And you have to have that record so that I can show, when you decide to terminate them, that we've enforced this provision, and we gave him chances, and he breached it each time, and now we're done with him. And it'll be easier for me to win that case than the case where you just let it go for all those years, and then really it's just trying to use it as an excuse to get rid of the problem franchisee.
Most franchise agreements these days have a 3 strikes default clause in them. Keep track of them. Keep track of them. They typically say that it doesn't matter whether the breach has been cured or not. Franchisees don't particularly like that because they think that a cure should be a cure. On the other hand, if you've got somebody who just can't keep it between the rails, you've got to do something about it. And again, the sooner the better. So what about trying to avoid this situation in the first place? Are there things that you folks do during your sales process, for example, to identify people who may not be a good fit and who may be problem franchisees later when you're qualifying them?
You want to start, Chris, or you want
Sure,
me to
I'll
go
go. I recently took over Fran Dev, so I'm looking at the processes that we went through before and realizing that we probably didn't do a great job at that and really vetting our potential franchisees. So we're revamping that, but as you said before, it's, that one problem franchisee, takes 90% of your time. And usually, like, I have a couple that are real small, and I'm on the phone with them every day. And, they're not good conversations. It's not good for your mental stability and your mental health, because they're trying to pull you down. Why'd you do that? I'm like, everybody else loves it. You don't? No, that sort of thing. So it's really, really important to vet. And, we talked earlier, we were talking about, the pulse test when you're a young, emerging franchisee. Is like, he's got the money and he's got a pulse, you're in. And then that becomes a real problem sometimes. So, we're now doing background checks, we're doing credit checks. And, what we found for us, it's capital-intensive business for us. So what we found is they really have to have the staying power. So we're requiring more capital and more money in the bank after they make the purchases and what they do, and just looking at it much more closely. And we're saying no. And I don't think we ever said no before. And some people are surprised by that, but I think at the end of the day, what we're learning is that it's just so much of a time suck for franchisees that don't want to follow the system, that think they're the smartest guys in the room, and they just create so many problems for everybody, and then they're chit-chatting with everybody on the back and really, really undermining you. And that's the biggest thing. So kind of comes full circle. You get the bad franchisee in there, and if he happens to be what we affectionately call a yapper, and he's going throughout your network and saying all these horrible things, or saying this doesn't work, and that's when it's really, really bad for morale. So sometimes you're better off to just pull that trigger really quick and get that bad seed out, and you made a mistake, and move on with your life. So, yes. I use Insperity, who's my HR firm, so I can run them through there.
Yeah, it's different platforms. I don't know which one we use at Horsepower, but they're fairly inexpensive, and there's a lot of options. I wouldn't say there's like one that's the best. They're all going to deliver pretty much the same result. One of the comments I would make on the back of what Chris was saying is, if anybody ever tells you they've figured out the right avatar for their business and exactly how to award territories to the right people, they're lying to you. After doing over 1,500 territory placements across my businesses in the last 12 years, we look for character more than anything, and people that will fit our core values, because it's like some of your best employees, you hire for character, you train for skill. And if you look through your entire organization, oftentimes the people that are truly your rock stars aren't the people that you hired for that specific position that came with experience, or people that either have moved up or someone that you believed in that really took to that role in a very good way. So one of the hardest things you're going to do early on in awarding territories is you're going to be anxious to want to get deals sold, and you're going to regret it later in some of those things, because like Chris said, if you're not saying no, and it's something that every month at our monthly Discovery Days, we'll bring 35 to 45 buying groups to our corporate office in Omaha, Nebraska, and there's at least one or two that we say no to, that the money's ready to go. Like, they've already started the funding process of doing a 401k rollover or submitting their SBA loan application, because they know that this is the brand that they want to go with. But then we have to be the bearer of bad news to say, we don't think it's going to be a good fit. Or maybe we put them through, prior to giving them a hard no, we'll put them through an additional line of screening where they'll have to go back and have another meeting with the brand president. They'll have some meetings with some of our executive team members to ask them some harder questions, or maybe get some additional documentation to back up some of the things that they're sharing from a financial perspective. The other thing you have to be cautious of too is those people that are very anxious to join the brand, that they're not thinking through all the work that's about to come on their plate. So as a franchisor, you walk on eggshells, because through a development process, you want to be very cautious about, if they're not asking you questions about the difficult parts of the business, you don't want to volunteer that information. Well, you're doing yourself a disservice, because if you think about, if through your development process you share the good, bad, and the ugly, the people that are going to make it through are more than likely the people with the thicker skin. You don't want those people that aren't asking the right questions, and you're not volunteering that information to just make it through just so you can get a deal done, because it won't end well. You're not going to survive as an organization on just initial franchise fees. It's going to take a franchisee to really ramp up. And David Barr showed that curve yesterday of, where the franchisee relationship is, where the royalty revenue for the brand and the cost for the brand at the support level, and where they sort of intersect, and being able to maintain that relationship long term. So don't be anxious to sell deals just to get deals done. And more importantly, read through too when you meet people at these events. There's a lot of people that will BS you on the size of their business too. So don't be afraid to go fact check some of the brands you talk to and look at their FDDs. They're all public.
No, I was just going to add, I think it's much better to lose out on that $50,000 franchise fee than pay me $300,000 or so later to deal with a bad franchisee, right? So I think it's extremely important. I know there's a desire to sell, especially when you're new and you're emerging and you're growing, but you have to resist that desire to sell sometimes and make the right decision on who you're letting into your system.
So Frank, you're big on enforcement and reading the franchise agreement. Are there particular provisions that you like to see in franchise agreements that help this process? I mentioned the 3 strikes thing, but I mean, what about dispute resolution provisions?
Sure, dispute resolutions is a very important one, right? When we were preparing for this, we discussed, do we like arbitration? And Peter and I had the same exact reaction. It was pretty funny, right?
Yeah.
We both looked at each other and had like this painful grunt on our face about well, I hate arbitration, but I love arbitration clauses. And why is that? Well, arbitration, it really doesn't end up being any less expensive than court, which was the original idea. It was quicker, cheaper, but that really doesn't happen. Lawyers have a way of complicating it and making it just as expensive as court, right? But the benefits of an arbitration clause is that you can enforce it and limit franchisees to just being them, right? And what I mean is, you can, if you're in court, you might have an army of angry franchisees, and they might all team up against you and sue you in some crazy big case. And it's much easier to get out of that in an arbitration because you can enforce the arbitration clause against each individual franchisee. But when it comes time to go to the judge and say, Judge, each of these franchisees have different cases, different facts. I don't want this. You need to dismiss this case or separate out the franchisees. Judges most likely aren't going to do that, right? Because they don't want to see judges have busy dockets, and they get in trouble if their cases last too long in some courts. And so they don't want to have 18 cases on their docket. They'd rather have just one. So the way the judge is going to look at it is, well, I'm going to conserve judicial resources by allowing these franchisees to pursue all their claims in this one case. I've had cases where that's happened, unfortunately, right? But with an arbitration clause, I can go to the judge and say, you got to dismiss all these cases, and each one of them has to file an arbitration. And they can't file them together in an arbitration if you have an arbitration clause that says I can't do that. So you can't have that collective action. And then when you go to the arbitration, another benefit of arbitration actually is that it's extremely expensive to file an arbitration, right? Depending on how much they're suing for. It could be upwards of $8,000, $9,000. Some franchisees who are struggling may not have the money to pay that. So it's going to discourage them from filing the litigation. And that leads me to my next point. That's one of my really big points that I like to make when I deal with franchisee lawyers, is that the mediation provision. I think you absolutely have to have a mediation provision in your franchise agreement. That's a precursor to any type of litigation, whether it's arbitration or not, right? And that's extremely important because it prevents you from getting an item 3 disclosure. Because once they file that arbitration or that litigation, you now have to update your FDD, you have to tell them you're being sued for fraud, and good luck trying to sell a franchise with that in there, right? Now it becomes much harder. So the mediation provision actually gives you a chance to resolve that case, because if it's resolved in mediation, you don't have to disclose it. But if it's resolved while arbitration or litigation is pending, not only do you still have to disclose it if you settle it, you have to put the settlement terms in there. And every franchisee is going to know exactly what you paid this guy to get out of the system. May find out anyway, but at least you can try to enforce a confidentiality provision and prevent that from happening in a settlement agreement in mediation. Something that I like to see in mediation provisions too is requirements, steps. Because a lot of franchisee lawyers think, well, if I file a lawsuit, that's going to put pressure on them to settle because now they have an item 3 disclosure. I actually think it's the opposite. It encourages a franchisor to defend a case, right? Because you want to win now, right? You don't want to settle and have to pay him $500,000 and tell everyone you settled for $500,000. You want to prove that the franchisee's wrong. And so I think it actually discouraged settlement, but for whatever reason, franchisee lawyers can't get that through their head. But I always try to explain that to them, and I actually have occasionally been able to get them to dismiss their case, because I think they see what I'm saying. So the mediation provision is extremely important, but you also want to have, like I was getting at, is you want to have checkpoints, so that you make sure that the mediation is enforceable, and someone doesn't just show up to the mediation to check that box, right? Because how do you force somebody to mediate? Well, you can do things like, well, you got to mediate for at least 4 hours, or you've got to mediate, and the mediation can't end until everyone agrees it's done, or until the mediator agrees it's done. There's a lot of little triggers we can put in there to require them to continue mediating and to mediate in good faith. They may still not, right? But if you've been there for 4 hours, they may start wanting to, they want to get out of there, right? And they maybe now they're willing to actually talk about settlement in good faith. But at least it gives you a tool to delay that lawsuit and try to get it resolved before it becomes an item 3 disclosure.
One of the other things that I see a lot in franchise agreements these days is fines, non-compliance fees, where a franchisor is charging a certain amount per incident or per day that a violation continues. What do you think about those, Frank, and Josh, Chris? What's your experience with them?
Yeah, we don't have them in our agreement at all.
Okay.
So, and I think it's one of those things that collecting them may be difficult, and you're down that path. It's almost I don't know how enforceable they are, to be honest with you.
Yeah, I mean, putting aside the question of enforceability, which they may not be enforceable if it's looked at as more of a penalty than an actual liquidated damages, if you could make the argument it's liquidated damages and there's some reasonable connection to the amount that you're charging and the damage that you're receiving in some way, maybe you can enforce it. I don't like them, though, because really you're just making the problem worse, right? The franchisee is going to be upset that you're charging them this $500 fee for every week, let's say it is, that they're out of compliance, and then so maybe they get the compliance issue resolved, but now they owe you $1,500, $2,000. They're not going to want to pay that, right? So I just think it kind of makes the problem worse. I don't really like them, but
No, fair enough.
Yeah.
Fair enough.
We don't put fees like that for out of compliance in any of our agreements. We're in a home service space, so there's a lot less things that people could do to be out of compliance versus running like a retail store. But one thing I do want to add to what Frank was saying earlier about the steps of the mediation provisions and things of that nature in the agreement, think about the steps of what you're doing as a franchisor leading up to somebody getting to that level of a dispute. So being proactive versus reactive is always going to be very helpful for you. So think about like a performance improvement plan that you develop long before you have an underperforming franchisee, so that when you have someone that is underperforming or you see that's leading towards potentially bringing a dispute, what they don't realize is that they're going to accept the help from you, and you're going to now put a little bit of extra time and attention not only into the training, but also gathering facts from them, better tracking their activities, to be able to, once you get to the dispute process, if it is a mediation or an arbitration, you're going to now be able to prove that leading right up to that point, as they were going through that PIP program, that they weren't doing the things they were supposed to be doing. And the reason why, because most of these disputes arise out of underperforming franchisees and people feeling like they were sold something that they weren't able to achieve because you had an item 19, and even though it says that, they may not attain these results, they still, in their head, a lot of times what franchise candidates think is, well, I'm getting the systems and the processes up front, so I'm going to be able to do better than Frank did when he founded this business because he had to come up with all the systems and processes. And so, they think, as I said earlier, they're the smartest person in the room sometimes. And if you can just think through those things, like I always say in everything we do, think like you're playing a game of chess and you want everything to end in a checkmate. And if you're playing chess and your franchisees are playing checkers, then you're going to be in a very good spot.
One other possibility wanted to explore is what happens if a franchisee comes after you with a claim, rather than you necessarily going after them and starting the fight.
Well, I mean, a lot can happen with that. I mean, like I was saying, I think you want to push it into mediation. Hopefully you have a mediation provision. If you don't, I would reach out to the franchisee or their attorney and try to negotiate, like, hey, let's just mediate this dispute, because, like I said, if you sue me, you're going to make it less likely for me to settle. You're going to make it more difficult for us to settle. And maybe, maybe you got a hard-nosed lawyer like a Craig Trachtenberg, who's going to be like, you know what, I don't care. I don't care what happens. I want to go to court. I want to sue you. I want to make it an example of you. You get some lawyers out there who have that mindset, and hopefully the franchisee doesn't have one of those.
Yeah, exactly.
Right? I mean, I don't know what to say about that. It's unfortunately, I deal with, there's a couple of them that I'm dealing with right now, and they're hard-nosed and they don't care, and I don't really think they're doing a service to their client.
But I think that's the other side of the coin. We talked about arbitration and mediation, which my franchise agreements don't have either, and which they will now going forward. When you start thinking about these things, if a franchisee is coming after you, he's still got to go through that mediation or arbitration phase, which hopefully you can get rid of the case before it becomes a filed case in court that's disclosable.
Excellent. We've got a little bit of time for questions yet. Does anybody have anything that they'd like to ask? Sure.
So we're a new emerging brand. Our first franchisee is not a good fit by any means. Fit financial profile, but the separation of like myself and a couple of my sales guys, where they thought we were best friends and could just chat all day long about, not about the business, just about life. And so you start to separate yourself, and they almost feel like they're abandoning them, even though the support side is still there. And so how would you kind of look into that as far as like now they feel like you've abandoned them, and now they start looking for faults in your system that aren't there in order to kind of make themselves feel better about that situation?
So I've dealt with that in a big way as we've built horsepower brands. We started with our first portfolio company, Mighty Dog Roofing, back in early 21. And then as we acquired brand 2, and now we're on to the 8th one and many more coming in recent months, some of those earliest franchisees feel like as a leadership team has expanded that, they don't have access to the same people that they were originally working with. So no one likes change, and there's always going to be some level of jealousy too, because some of those earliest franchisees will sometimes make comments like, well, if it wasn't for us taking a risk on you early on, you wouldn't even have what you guys do today. And you just work through those. You can't get offended by some of those comments, but definitely making sure that your relationships with franchisees remain very professional and not friendships. You'll have some friendships that will develop, outside of, you might travel into a city where someone is and you might meet them for a meal, but I wouldn't recommend getting too close to it. What we advise many of our employees to do is actually set up 2 social media accounts, maintain a personal account, and then set one up for business purposes, and to avoid friending any of the franchisees through any of their social media platforms on their personal stuff, and then just keep them separate. And then our marketing department too, in some regards, will even manage those business accounts for them to regularly post business-related items. But we have a phrase that we use at Horsepower with our development team, and it's don't do any hot girl shit, because what we do is, what we mean by that is like when you're chasing the candidate and you're trying to give them more than what they really need, like our job in franchise development is to be an educator. Like just deliver the information, let the person receive it. They're dating other people too. They're looking at other opportunities. But 100% of the time when we've tried to force a sale or work too hard to get someone to join the organization, there always becomes a level of buyer's remorse. So the thing that you have to keep in mind is like, let the candidate make that decision. And in the earliest deals that you do, you're anxious to get those done. And you tend to want to try to give them more. When you've got another franchisor that they're working with that might be more sophisticated that's not chasing them, it's going to come across as much more professional and a standard process. Because people in life, just psychological, we all get put through processes every day of the week and everything that we do. So don't feel like you have to have too many touch points. Just create the process, stick to it, and if someone's not the right fit, let them move on. There's no back-end deals. Like if someone, comes to a discovery day and afterwards says, I don't think it's a right fit for me, we're not then going, well, what if we throw in a free territory? What if we give you a couple zip codes? Like that's just what it is. Because I've heard many stories where we've had competitors offering multiple free territories to try to win someone over away from us. And we just let them know, like, you're going to make the decision that's best for you. So, but that's a frustration you're going to deal with franchisees feeling like you're moving away from them.
And I would add just from that, it's very difficult now because you're small and you're emerging, starting out. As you get a little bigger, the way we deal with it is we have a Fran Dev person, and they become buddy and they become friends. But we kind of explain the process. It's like, okay, you're going to deal with me, then we're going to introduce you to the CEO, then we're going to do this, and then once you're up and running, we have our onboarding specialist, and that's really going to be your primary contact at that point. And then they're with them, and they can answer their calls and that sort of thing. And they still know you, if you're smaller, and they still feel they can call you, and which is they should, and which is fine. But it separates out a little bit, and if you explain the process to them in the beginning, it's like, yeah, you're kind of our first one, but we're going to be hiring people that are going to handle our relationships. It may help a little bit to navigate that social relationship down the road so I don't feel as abandoned. It's like, remember I told you that? That sort of, that's what I try and point to everyone. We talk about, don't just say it's all, roses and it's great. You got to point out the bad stuff. It's like, hey, this is really tough. And remember I said that. I try and use that a lot. It's like, I told you this is going to be difficult. Your first year is going to be tough, and here's why, and this is what's happening. We're seasonal, and now Christmas is coming, and you're worried that your business is going to fall through the floor. It won't. This happens every year. Relax. Everything's good. Remember? We talked about it. That sort of thing.
Anyone else? Sure, please.
How do you go about educating your FBCs on like the FDD and the franchisor data? To what extent do they need to be knowledgeable?
We don't really educate our FBCs on the franchise agreement because our franchise business coaches are really there to train on the industry and support the franchisee in their daily operations. They're not the compliance person outside of if they're going through a regular site visit check, or we'll call them operational service reports, then they'll go through those, and if there's a violation of something that they're clearly aware of, they'll review those, obviously with the brand president. But I don't know that you necessarily have to train your FBCs to know the ins and outs of the agreement.
Ours are asking for like more information because they get questions. So I'm not sure if we should just tell them, give it to compliance, just have the FBC direct it to compliance, direct questions to the compliance person.
Yeah, they could funnel it up to the person that would know that, or if it's a common item that's coming up, to make sure everyone's aware that this question's coming up, then that's one way to address it.
Do you have more than one version of your franchise agreement, or is it pretty?
Yeah, we think that we.
Yeah. Yeah. So that makes it a little tougher.
Yeah.
Yeah. Any final thoughts, anybody?
No, just thank everybody for coming
Yep,
in.
thanks.
Hopefully it was helpful.
Well, I have one final thought.
Excellent.
Get releases.
Sure, by all means. Sure.
So I have a question on the release.
Yeah.
So is it kind of like a boilerplate type release, or like could you like speak to maybe a little bit of detail, like an example of?
Well, you want a general one, right? It's going to cover everything. It's going to, and also you need to look at what state you're into, so you should definitely have your lawyer look at it. For example, California has special requirements for their releases. So you want a general release that releases all claims, known and unknown, and whatever else language is required. But in order for it to be enforceable, you need to give them something in exchange. You can't really just take the release. So that's why I said when you give them financial considerations, or if you give them some benefit, like we've trained you and we'll waive any fee that you might have to pay under the franchise agreement, or you know what, we'll give you a break on your royalty. Any of those kinds of things. Get the release because now you have that exchange. But something that's also really important that just comes to mind, and he's not in here so I can tell the war story, because he told me not to tell any war stories, one of my clients. So, if you get a release, make sure the release has all the right parties on it, okay? A lot of times you'll have the franchisees maybe sign individually, and then they assign the franchise agreement to their entity, and they guarantee it, right? Personally guarantee it. If you draft a release just for the entity and forget the individuals, or vice versa, right? You've released one of the parties, but not the other party. They may still have their claim. That actually happened in a case of mine, where I thought I had a release, was all excited, then I realized, wait a minute, the person who drafted this release forgot to put the entity onto it that they assigned it to. He just looked at the franchise agreement, whoever drafted it, saw the names on the franchise agreement, forgot to look to see if it was ever assigned, put the release in the individual's name, and the franchise lawyer said, well, guess what? The entity is still isn't released, and they still have their claims. So you got to be very careful of that. Always have your lawyer look at it, and make sure you use the right lawyer, because the person who drafted that release was a lawyer. It wasn't me. It was a different firm. But yeah, so those are important things to look for. But there's really, it's kind of a boilerplate language, the release part, but you got to make sure you have all the things in there that's required to make it enforceable, because, the franchisee lawyer, the first thing they're going to do is go after that release hard, right? They're going to say there's no consideration, or they were tricked into it. You want to make sure that you have the consideration and all the things in it that you need to make it enforceable.
Great. Well, thank you very much, everybody, for coming. Great questions, and hope you got something out of it. Take care. Enjoy the rest of the day.
Thank you.